Let's start with, firstly, I want to thank you. I think it's a point to make from myself that when the committee invited you, you didn't get sick, you didn't proffer any resistance to come to the committee. And you furnished us with a statement that you've gone through with annexures. I think that's helpful for the committee, and I personally am grateful for that. I note I might have missed it in your statement, and please help me understand. It's a very detailed statement with detailed annexures, but I missed your exiting media statement. Is it in the document that you've included in your statement? Not that you were obliged.
No, I did not include it because the exiting media statement was not the formal document by which I exited Eskom. The formal document by which I left Eskom to go on retirement was the letter that I wrote to Dr. Ngubane. So the media statement was something that I wrote, and but it is not a statement that I think would go to my personnel file at Eskom. What would have gone to my personnel file, and the treatment of my retirement would be treated in line with the formal letter that I wrote to the board when I was exiting Eskom. So I did not think, although it is something that I did not think that it was relevant to the formalities of my exiting.
When you left Transnet, what was the form of you exiting Transnet? Was it by resignation or was it by early retirement?
I resigned.
So you went to Transnet having made a decision that you'd secured employment somewhere, you're leaving Eskom. Transnet.
Yes, having been persuaded.
And that it was your unilateral decision. You did not need permission from Transnet to grant you permission to leave Transnet.
No, I did not.
The reason for that, you are correct, is because a resignation is a unilateral act by an employee. In other words, you do not need the employer to give you permission to leave. You can confer with counsel on that legal submission.
Yes, it is. I'm advised that it is unilateral to the extent that it becomes accepted.
But you made a decision, you communicated it to Transnet, and you went away to Eskom. The early retirement is different from the resignation because you need to source consent from the employer. Your leaving is not only at your discretion. Is that your understanding?
Yes, that is correct.
And that is why you would then have addressed a letter to Eskom asking for permission to retire early.
Yes.
But let's go then to your a media statement. I don't know what they call them. I'm not a media person. But I do have it here. I don't know if you still recall it.
Yes, I have it, I recall it.
Do you want me to give it to you to read for the record?
No, that is not necessary.
Let me read it then for the record.
Yes, sir.
It is dated the 11th of November, 2016. And it says, on Wednesday, 2 November 2016, a report entitled State of Capture, prepared by the former public protector, Advocate Thuli Madonsela, was released. The report did not make any findings. Instead, it made what were termed observations. Based, the report acknowledged, on an investigation not completed. It deferred a proper investigation to a commission of inquiry to be established at a future date. The outgoing public protector has directed the president, in whom the Constitution vests the power to appoint commissions of inquiry, to appoint one, and further directed the Chief Justice to designate a particular judge to head it. It is a matter for regret that the report was prepared in haste to meet a deadline related to the public protector's own departure from office. That office continues, as all state offices do, and that any uncompleted function is completed by a successor in that office was not a consideration in the report. In inverted commas, observations made in the report relating to inter alia my conduct are in material respects inaccurate, based on part facts, or simply unfounded. What the previous public protector has done is not herself to investigate to completion or to allow her office to complete what she initiated too late to complete herself. She has also determined on recording quote-unquote observations without, in crucial respects, putting intended harmful disclosures to me first, as she was by law required to do so. She has effectively deferred my constitutional right to be heard to a future date and to a further body, which she has ordered others to assemble. If such a body is indeed by law to be assembled and carry out the task, it will not be for some time, as recent experience indicates. In the meanwhile, harm is done to the institution. It has been my honor to lead in the most difficult times, to its reputation, to my own. I say nothing of the harm to others close to me. I am confident that when the time comes, I will be able to show that I have done nothing wrong, that my name will be cleared. I shall dictate myself to showing that an injustice has been done by the precipitate delivery of observations in inverted commas, following an incomplete investigation, which the former public protector has drawn back from calling in inverted commas findings. The truth will, I thought you say the truth will come out. That's what you want to know. I have, in the interest of good corporate governance, decided to leave my employ at Eskom from 1 January 2017. I do so voluntarily. Indeed, I wish to pay tribute to the unfailing support I have had since I took office from the chairman, the board, and with those with whom it has been my privilege to work. Together we brought Eskom from the brink. I will take time off to reflect before I decide on my next career move. I wish to reiterate that this act is not an admission of wrongdoing on my part. It is rather what I feel to be the correct thing to do so in the interest of the company and good corporate governance. I wish to thank the shareholder representative, Ms. Lynn Brown, the board, the executive team, and all Eskom employees for their hard work and guidance in steering the company out of the very difficult times during the 20 months that I was privileged to be a group chief executive. I go now because it is in the interest of Eskom. It is in the interest of Eskom, the public it serves, that I do so. Bright Molefe, dated 11 November 2016. Anything said in this statement that is attributed to yourself, do you associate yourself with it?
I associate myself entirely with that statement.
The reading of this statement makes it clear that you are just want to go back to the relevant paragraph. You say you've decided to leave your employ at Eskom. That sounds a unilateral decision. Would you agree?
Mr. Vanara, I don't know if you are trying to say that that statement was a letter of resignation. And if I had not done anything but write that statement, if my employment at Eskom would have terminated. I'm not sure. I mean, maybe this is a matter that will be determined by the court next week. But if I had written a statement like that and put it in the public domain, I don't know if that would jolt the Eskom HR department and the EPPF to suddenly start paying my resignation benefits because of that public statement.
We're coming to the pension, not so fast.
No, I wasn't talking about the pension. I was just saying, I don't know if you are trying to say that that was a resignation letter.
You have eloquently articulated the point that this issue is a source of a legal dispute.
Indeed.
And we're trying to get ourselves out of the mist. And that's why we need to look at all the relevant documents to assist us understand what you would have meant in your media statement. And it forms part and parcel of assisting us. Because your minister, that you thank in your statement, in the court papers that I've read, at least, is challenging your assertions that you did not resign.
Is the minister saying that she understood that press statement to be a resignation letter?
You see, it is the other way around, unfortunately. I ask the question, and you respond. You have asked.
I just want to understand your question. So I'm asking for clarification of your question as to if you are saying, are you therefore saying to me that the minister's conclusion is therefore that that statement was a resignation letter? I just want to ask if is that your question to me?
No, that is not my question to you. Please, the minister will come and testify for herself what her understanding is of your stepping down from Eskom. All I'm saying is the minister in court documents is challenging your assertions that you did not resign. She's of the view that you've resigned. Dispute that. The minister is challenging your statement that you did not resign.
I cannot speak for the minister.
I
If
do
the
accept.
minister is challenging, if the minister has said something or has made a challenge in the court documents, she has made the challenge. And if she wants to explain it further, I'm sure she will explain it to you when she comes here.
I would never make a mistake of asking you to speak for the minister. Listen to the question. Listen to the question. You want to find out why am I bringing all this information? Why am I inquiring into this aspect? The point I'm making is it is a source of legal dispute. That is the point that I want to make. Let's move on. Going back to the statement. I'm asking you that my reading of that statement reflects a unilateral decision by yourself to walk away from Eskom. Is that understanding correct or incorrect?
Mr. Vanara, the matter will be determined by the courts next week as to whether that statement was a resignation letter. The statement may have expressed the fact that I have decided to move on. The question that I have, however, is, was the statement sufficient to be classified as a resignation letter in terms of the formalities at Eskom? I don't know, and that is why the matter is before the courts.
But you're before Parliament, and you have a constitutional obligation to account to Parliament. You were a group chief executive of Eskom. I hope you haven't forgotten about that constitutional obligation you have. Have you?
I have executed it in the sense that I have said to you that I do not consider the statement to have been a resignation letter.
No. You must answer the question that I ask. I'm saying my reading of your statement, when you say, I have, in the interest of good corporate governance, decided to leave my employer at Eskom, to me, suggests that you on your own took a decision that you were leaving Eskom. Is that a right understanding of what you've written in a statement? Yes or no?
It is. However, it's not a straightforward answer of a yes or no. The question is, does that statement constitute a resignation letter?
You stepping down, it is your unilateral decision, and it is for good corporate governance. Those are profound words. Those are profound words. And it is because the Public Protector's report has made these observations. You want to give the process time so that you can clear your name. Have you had an opportunity to clear your name as of to date?
The Public Protector did not make any findings. The advice that I got was that in the absence of findings, there is nothing to clear. She just made observations. She doesn't even say that I met any of the Guptas. She says, I was in the Saxon World area. I don't know, Mr. Vanara, if you've ever been to Saxon World.
I haven't. I don't know how Saxon World looks like. But let's come back to where we are today. You see, there appears to be a contradiction that you are making. You say the public protector, I accept in your own statement, you're not saying there are findings against you. You're consistently saying observations. And you say there's nothing to clear. But in your statement, this is what you say, nobody else. And I'm on that statement. It is your decision that you make because you want to clear your name. Can you record your response?
It is my decision that I want to clear my name. But lo and behold, when I go and get legal advice about how do we then start clearing my name with this public protector's report, the lawyers say, but there is no finding. What is there to clear? I had a strong feeling, and Vanessa Klein also said this earlier today, that report needed to be taken on review. But the lawyer said, what are you taking on review? There is no finding. There's only one thing that the public protector said for certain, that the president must establish a commission of inquiry. And he has instituted a review. But the lawyer said it is ridiculous to think that you can say the public protector said you were in the area of sex and world and you want a judge to review that observation.
I'm not interested in what you find out subsequent you making the statement. I'm at the time you're making the statement. That is where we are. At that stage, is it correct that you wanted to clear your name?
Yes, it is correct.
I'm asking if there has been an opportunity, because you seem to be saying in your statement, these things are going to be investigated further because the report itself is not complete and the public protector has recommended for a commission of inquiry.
No, I did not say so. I said the public protector herself says these things must be investigated further. So there has not been an opportunity to clear my name because she did not create an opportunity to clear my name. If there had been a further investigation, perhaps findings that could be challenged or proper observations that alluded to, I don't know, wrongdoing and so on, maybe there would be an opportunity to clear my name. The frustration that I had and the thing that I was really very emotional about was because the public protector had written this report that said neither yea or nay, and yet that had weight in the public domain.
Yeah, now let's just focus on these proceedings for now. The employer, your employer at the time, Eskom, through the board, issues a similar statement on the same day. You know about the statement?
Yes, sir.
Let me remind you what Eskom said. It is the Friday, the 11th, 2016, the same day that you made the announcement. And this is the heading of the media statement. Eskom GCE Brian Molefe voluntarily steps down. Friday, 11 November 2016, it is with a great sense of loss and regret that the board of Eskom announces a decision by Eskom Group Chief Executive Brian Molefe to step down in the interest of good corporate governance. In an effort to clear his name, following the release of former Public Protector Tulima Donsela's report on her observations about the so-called state capture, Mr. Molefe has decided to voluntarily step down, to reflect and take time off. Eskom chairperson Baldwin Ngubane said the decision taken by Mr. Molefe was regrettable but understandable. Since joining Eskom in April 2015, Mr. Molefe and his executive management team have turned around the company's operational and financial performance. With 15 months of no load shedding, the impact of which has been enjoyed by every South African citizen. The improved performance of the power generating units, coupled with additional capacity from some of our new build projects, has resulted in a stable power system, with excess capacity being exported to neighboring states. The company's liquidity position has also improved significantly, with liquid assets increasing by 81.6% from 24.1 billion a year ago to 43.8 billion at 30 September 2016. In the face of CPI growth reported to be 5.1% as at 1 April 2016, the group has access to adequate resources, facilities to continue as a going concern for foreseeable future. The Eskom board sincerely thanks Brian Molefe for his relentless dedication to turning Eskom around, solidifying a capable executive team and putting on a sound growth trajectory. Eskom will soon be announcing the interim leadership arrangements, once agreed with our stakeholder representative, the Honorable Minister Brown. That's where the statement ends. From this statement, I read the following: that your history at Eskom, they're looking behind you to get your replacement. From this statement, what is your take?
I think you're not correct, Mr. Vanara. The operative word there is decision. Mr. Brian Molefe has taken a decision to step down. At that point, I had issued a statement, Eskom issued a statement. Do the two statements constitute the action of resignation itself, or just contemplation, or just communicating a decision? You see, you can decide to go to Bloemfontein as you're sitting here now. It doesn't mean that you are in Bloemfontein or you have gone to Bloemfontein until you actually do it. So that was two statements that talked about a decision that had been made but not implemented. The decision was implemented a couple of days later when I, in fact, formally wrote a letter requesting early retirement. Had that early retirement been declined, I would still be at Eskom.
That, with the greatest of respect, and if this is your attitude to responding to questions, we'll leave here 1 a.m.
Perhaps that is why we must leave it to the courts.
No. You must please assist the committee by responding to the question. I've now gone through the trouble of reading Eskom's statement, not your statement. For now, we're done with your statement. We're talking about this statement issued by your employer. And I'm saying to you, what I read from the statement when they say, for instance, Eskom will soon be announcing the interim leadership arrangements once agreed with our shareholder representative. They thinking behind Brian Molefe. Is that a fair reflection?
I think Eskom was appreciating the fact that something was about to happen.
So when the board says Eskom board sincerely thanks Brian Molefe for his relentless dedication, was this a thanking in advance?
No, no, it was just a thanking for my relentless dedication.
The minister will be here tomorrow, and one of the questions she will be responding to is on her understanding of you stepping or leaving Eskom. But the papers that I've read seem to be consistent with your decision that you communicated through your statement, seems to be consistent with what I read from your employers. And it is a version that she has put before court. I don't know if she's still going to put it tomorrow, but I'm saying the one that is before court is that you resigned. What is your response to that?
Mr. Vanara, if you go through the documents, you will see that the minister put a version before court at the beginning of the of the High Court application, under oath. And in that version of hers that was deposed in an affidavit under oath, she said that she accepted the common mistake that had been done and accepted that therefore the legal position was that Mr. Molefe could return and that Mr. Molefe had not resigned. Later on, she changed a version that she had already put before court under oath to another version, and even later on, a third version. So I will say to you, Mr. Vanara, if you go through those documents, you will find 3 versions under oath by the minister.
In the internal communication that Eskom sends to the staff that you are leaving behind or you left behind at Eskom, Dr. Ngubane tells the officials at Eskom that you had resigned, which seems to be consistent with the statement at least made by the board. What is your take on that?
Do you have the internal communication, if I can look at it?
Yes, I do have it. I can read it for you. I can read it for you. Sorry.
In the meantime, you can take some water. Sir.
I'm fine, ma'am. I'm fine.
I'm referring to our witness.
Oh, okay. 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 This is the statement. It comes from a message from the chairman. It reads as follows. Okay, I'll check on the date. But let's first read the statement. Dear colleagues, the Eskom board recently announced the resignation of Mr. Brian Molefe as Eskom Group Chief Executive Officer effective 1 January 2017. To minimize the impact on business operations, the Eskom board is pleased to announce that Mr. Machela Koko, currently Group Chief Executive, Generation Division, has been appointed as Acting Group Chief Executive Officer as from 1 December 2016. Mr. Koko will act until a new Group Chief Executive has been appointed. As from 1 December 2016, Mr. Koko is a member of the Executive Committee and has worked alongside Brian in turning operational performance of Eskom. We have full confidence that Mr. Koko will continue to steer organization with the same determination and drive. Mr. Koko holds a BSc in Chemical Engineering from the University of Cape Town and an MBL from UNISA. He has been with Eskom for the past 21 years. I would like to thank all employees for your sustained contribution during this transition period. I encourage you to continue with your efforts under the new leadership of Mr. Koko and the executive team as you continue to contribute to South Africa's growth and development. Please join me in congratulating Mr. Koko on his new appointment. Unfortunately, I don't see a date on this statement, but I'm sure it's an issue that could well be clarified. But the point I'm making is there seems to be consistency. One, in your unilateral decision. Two, in the communication, at least from Eskom to the world and Eskom internally, around you having resigned. What is your response to that?
I don't know if Mr. Ngubane wrote that statement or when he wrote it, but what is of significance is the letter that I wrote to him was to request for early retirement. Now, the reason I was asking when he wrote that was to determine if he wrote that statement after he had received the letter that I wrote to him, in which case I would be surprised why he did that. But needless to say, Mr. Ngubane later on had an opportunity to make an affidavit under oath in these court proceedings. And in that affidavit, he says, I took early retirement and I did not resign.
I accept that, and we will deal with Dr. Ngubane when he's fit to come testify before the committee. But from what we have now, as we speak in front of us, would you accept that it would appear that the evidence suggests that you resigned from Eskom.
I do not understand why, Mr. Vanara, you are choosing to ignore the official document that I wrote that would determine whether or not I get early retirement, and insist that I have resigned when I have never written an official document that was going to go into my file of letter of resignation. I don't know why you ignore the fact that I did write a formal letter to the chairperson, as is expected of a person in my position, to say that I'm in fact resigning. I'm sorry, I'm in fact taking early retirement. And that you try to insist that I resigned because the unofficial documents say so.
Unless you want to disown your statement that you voluntarily communicated to South Africans and the world. Is that your stance now?
No, I'm not disowning it. I'm just saying that that was not a letter of resignation.
We'll get to the internal communication. We'll get to all of that. But for now, you must agree with me that from your statement on the 11th of November, confirmed by the board statement on the same day, that based on these documents, we'll get back to the others, based on these documents, and the only inference to draw is that you resigned.
Mr. Vanara, if you make a statement that you want to get married, it does not mean that you got married. And until you appear in front of a marriage officer and finalize the marriage, it has not happened. So, I do not understand why those statements, which are not official documents, constitute a resignation letter. But then again, I'm not a lawyer and you are an advocate, so maybe there is a legal side to it.
Let's go to the pension fund. In your narration of your statement, you come across as an individual who's very eloquent in the rules of the pension fund. Is that a fair assessment?
No, I wouldn't say I'm eloquent in the rules of the pension fund.
I'm sorry, I couldn't, I didn't get the answer. What is the answer?
Your question was, I come across as a person who is eloquent in the rules of the pension fund. I say I do not consider myself to be so.
To the extent that you have been able to identify relevant issues that pertained to you getting a pension from Eskom, you seem to be demonstrating to the committee that you understand those rules, at least.
The rules of the pension fund, I understand because of the legal advice that I have received, and it has been explained to me what the rules say. So, on my own, I cannot call myself an expert on the rules of the pension fund.
So this statement of yours, did somebody draft it for you? The one that you read before the committee this evening, has it been drafted by somebody else on your behalf?
I drafted it, and because I have lawyers that have been working on this case, I got them to read it, and we edited it together. But it was a statement that I drafted on my own, and it was edited with the assistance of legal advice.
And you are satisfied that the statement reflects what you want to share with the committee?
Indeed, Mr. Vanara.
And therefore, when I say reading your own statement that you are happy with, I gather that you have a fairly good understanding of what the rules of the pension fund, at least those that are applicable to the pension regime.
Mr. Vanara, what I'm saying is I do not consider the statement that I have drafted to make me an expert on pension fund matters. You seem to say that because I wrote that statement, I must be an expert on pension fund matters.
I can assure you, you can, after these proceedings, play this tape repeatedly. You wouldn't find me making a reference to you being an expert on pension fund. The question is a very simple question. If you don't want to answer it, please say so, because I feel a bit wasting the committee's time. The question is, you've prepared a statement, you own the statement. You've taken us through the statement. And I'm saying, my reading of you is that you understand the relevant rules of the fund that are applicable to your pension regime. Yes, is that correct or is it incorrect?
No, it does not necessarily mean that I understand the relevant rules.
Let me point out a very simple rule, a very simple rule. And before I get there, earlier on you made two distinctions. You got a letter from both the minister and the board, Dr. Ngubane, saying you have been permanently employed. That was a testimony.
Yes.
And this, you were then, based on that, admitted to the pension fund as a permanent employee. That is a testimony.
Yes.
Within a matter of days, this thing gets to be sorted out, this confusion. I sympathize with you. Your employers did not seem to understand the regime that they were employing you under. Some were saying you are permanently employed, others say, no, let's change it, let it be a 5-year contract. I get that. That is the message you are communicating, isn't it?
No. It was not a matter of days. I was employed as a permanent employee. A month later, not a matter of days, a month later, a letter was received from the minister that I should sign a 5-year contract. The 5-year contract was signed in March the following year. So it was not a matter of days, and in fact, in my head, there was no confusion. I had been employed as a permanent employee, which was changed to a 5-year contract.
Exactly. When it changed, when your employment status changed, the pension fund is on record that they started deducting your contributions or receiving contributions later than the date that you had joined, but then the contributions were back paid. Any reason to dispute that testimony?
I don't know when the pension fund received the documents or when they loaded me onto the system. I really don't know. I have never investigated that.
If you don't know, then you must accept the wording of those who know. Isn't that so? You don't know.
Are you talking about faith?
I'm sorry?
Are you talking about faith when you say if you don't know, you must accept those that know?
I'm saying because you don't know when your contributions started to be paid over to Eskom. They might have been deducted from your salary or there must have been a confusion. But at least the pension fund knows when they started receiving your contribution, and you cannot challenge them on that.
Yes.
Now, when you knew then that the pension has now changed, I mean, your employment status changes from permanency to a fixed-term 5-year contract. And when the rules of the fund preclude contract employees from membership of the fund, on what basis then did you think you could become a member of the fund?
I received a letter from the minister on the 2nd of October, which had no limitation on, and I subsequently got a letter and a contract from Eskom. On the 1st of November, the minister wrote a letter to Dr. Ngubane. And after the minister wrote a letter to Dr. Ngubane, I got a letter from Dr. Ngubane, which is in the documents, do you know, which is... The letter from Dr. Ngubane on the 11th of November, page 52, says, you will be required to enter into a fixed-term employment contract. So, the actual entering into the fixed-term employment contract happened in March.
Much of which year?
2016, the following year.
But it is backdated, back to the 1st of October 2015. Isn't that so?
Yes, it is backdated to the 1st of October 2015, but between the 1st of October to the time when I signed the contract, I was a permanent employee until that changed. Now, what is interesting is that that contract that I signed in March also says you will continue to be a member of the Eskom Pension Fund. In the rules of the Eskom Pension Fund, I think it's rule number 13 if I'm not wrong, it says that if you have become a member of the pension fund, you will continue to be a member of the pension fund even as long as your service continues.
No, we're not there. I mean, clearly that means if you are eligible and you join, and you become part and parcel of the furniture, so long as you're in service, you become part and parcel of the fund. It cannot be interpreted to entitle eligible candidates who erroneously find themselves into the pension fund scheme to continue to be members of the pension fund.
I don't know. Perhaps you're saying that therefore that when I signed as when I signed the contract in March, my membership should have been revoked.
Not only from March. Remember, your contract of employment, albeit signed in March, you started earning a salary of group chief executive, not on an acting capacity, but as a group chief executive now, from October 2015. Is that not the case?
That is correct.
So, your actual employment on the contract basis starts on the 1st of October 2015, and on the 1st of October 2015, you are not eligible to become a member of the fund. In terms of not my rules, of the fund rules, which you claim to belong to.
But Mr. Vanara, the letter that I got on the 2nd of October and the contract that I signed shortly thereafter, in October, did not specify the term of contract.
No. Let us be clear on one thing. You are permanent at a specific time. It's communicated to you. I sympathize with you. But that decision gets to be changed. You had an option then to kick the fuss and say, I'm suing you for breach of contract, or I'm walking away from this thing, or I accept the new terms. That was a decision you had to make. You accept that?
Yes, I agree.
And you voluntarily took a decision to accept that 5-year contract of employment.
Yes, I did, sir.
And by accepting that contract of employment, you could not have been a member of the fund, because the rules of the fund, Mr. Sibu was here, says contract employees are not eligible to be members of the pension fund.
Legal counsel has just shown me a section in the pension fund rules, on page 78, which says an eligible employee is an employee who at the date of becoming a member, so at the date when I first became a member of the pension fund, I was an eligible employee. But I don't know if your point, therefore, is that in March, when I signed that contract that applied retrospectively, my membership of the pension fund should have been revoked retrospectively.
Now, I'm saying when you were employed on a contract, and that employment is 1st October, it gets resolved sometime in March 2016. But by virtue of the nature of your employment with Eskom, you are disqualified from being a member of the Eskom pension fund. That is what the testimony of the chief executive and the principal officer of the Eskom Pension and Provident Fund. What is your response to that? This is a factual issue, I think.
Well, Mr. Graves says it is a legal issue because if he said it, he's wrong in law. But I don't know, this is a matter before the courts. I also don't know why you're ignoring the fact that I had been a permanent employee until the change was made. Although it applied retrospectively. So I accept that it is a matter before the courts. But the point is, even if I had not been eligible to be a member of the pension fund, I have accepted that there was a mistake. Now, what you're simply proving is that there were a lot of mistakes, that I did not qualify for early retirement, which I agree, and now you're saying I was not eligible to be a member of the pension fund. Maybe the court will agree with you. It is a matter that will be ventilated between the legal people, but I accept that. I have already said that the whole thing was a mistake. And therefore, I asked, where does it leave me? Where do these mistakes leave me?
I accept your candidness, but there could well be another perspective to this transaction. And that is where I'm coming from. That you resigned, and the issue of the retiring on, the early retirement was an afterthought. How do you respond to that?
There is no other formal document that I wrote to the board about early retirement or resignation. There is only one document which said, I hereby request for early retirement.
Either way, you're requesting for early retirement in terms of the 9 February resolution of the People and Governance resolution. Is that correct?
Yes.
But clearly in terms of that resolution, you do not qualify. Accept?
Why do you say so?
Let's go back to that resolution. Do you have it? Just, is it part and parcel of your statement annexes? Can you draw me?
Page 64.
Okay. It says, at this meeting on 9 February, the People and Governance Committee, blah, 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 resolved the following. The current pension and provident fund rule that employees may proceed on retirement from age 50 with 10 years service remains applicable. Now, you're at Eskom for less than 2 years. So this can't be applicable to you. What is the answer?
So, paragraph 2 of that resolution says, in cases where executive directors decide to take early retirement and there is a shortfall regarding the EPPF's 10 years service rule, Eskom shall. So it dealt with the instance where you don't have 10 years service.
No. That is not what I'm reading here. Perhaps let me assist you.
Maybe you should read paragraph 2 then.
Now you need to read the entire resolution. Let's read the entire resolution.
Not one only.
Yes, let's read the entire resolution.
Okay.
Let me help you. The current Eskom Pension and Provident Fund rule that employees may proceed on retirement from age 50 with 10 years service applies. In cases where executive directors appointed on fixed-term contracts decide to take early retirement and there is a shortfall regarding EPPF 10 years rule, Eskom shall breach. Yes. So you must be 10 years at Eskom.
You must be 10 years at Eskom, and if you're not 10 years at Eskom, and you are an executive director who's decided to take early retirement, and there is a shortfall of the 10 years, Eskom shall breach. That's my understanding.
Okay, it is an issue of interpretation with which I differ with your interpretation. Nonetheless, you were not a member of the fund, irrespective of what they are trying to do. You didn't qualify.
Not only was I not a member, this resolution is wrong because it says that in terms of the pension fund rules, the pension fund rules don't say so. I have admitted that the PNG made a mistake. I have admitted. I have admitted in the court papers that there was a mistake. In fact, this mistake was the basis that made the legal advice, I'm told, to say that the situation must therefore revert to status quo ante because of the common mistake.
Okay, so I mustn't waste time. You accept that there was no basis for Eskom to pay money to the Eskom pension fund as a pension because of this mistake?
Yes, I accept that.
Sorry for wasting your time. I'm sorry for wasting your time. Okay, can we then move to others? You had it, and you are lauded for, and this is, I'm wrapping up. You are lauded for a very good work that you did at Eskom. I have no reason, I have no evidence to challenge that. But two of your non-executive directors this morning and this afternoon complained about documents that were submitted by your executives that were incomplete, that were misleading to a board of which you were a member of. What is your take on that?
Oh, that was a big problem, sir. Madam. The practice at Eskom, which was very foreign to me, was that members of the executive could compile documents and take them to board subcommittees as well as to the board without going through some process at the executive level. It is a culture that I tried very hard to change. The structure, if you look at the governance structure of Eskom, I think you must also look at the governance structure below the board. So you have BTC, Board Tender Committee. You had a committee in the executive that reported directly to BTC. Chief Executive was not a member of that committee and did not necessarily see the documents from that committee. It was a source of huge frustration for me. In fact, we tried to change that governance structure because the way that I would have preferred that we operate was that all subcommittees at EXCO level are subcommittees of EXCO. Everything that goes to board subcommittees and the board must actually come from EXCO itself. It was not always the case that things came from EXCO to the board. In fact, that was more the exception than the rule. The practice had been that there are subcommittees, BTC is one that comes to mind, that could meet, that are EXCO subcommittees, and then go directly to EXCO without having gone through the executive committee, or even without having made recommendations to the chief executive officer.
Lastly, on my side, let's deal with the target.
Tegeta, yes.
The prepayment. How come that Eskom prepays coal to a company that does not own a mine?
Firstly, let me put in a disclaimer. You will have noticed from Ms. Daniels' evidence or testimony that A meeting was called on the 11th in the evening. And I was not in that meeting, nor was I invited. She lists the names of people that were invited. But having said that, it does not mean that I do not know anything about the subject. I have appraised myself and I know about it. If you read Piers Marsden's testimony here.
Section 34 statement.
No, when he was here.
Okay.
Yeah. He says they had sold the coal to Tegeta. They had sold, the judicial managers or the business rescue managers had sold the coal to Tegeta. Let me quote him verbatim, because as you were talking to Veroshni, I went back to his testimony and I got the exact quote. On a question from Mr. Vanara, Mr. Marsden says, and I quote, "I think, first of all, the rationale for the money would need to be interrogated in the first place. Optimum Coal Mine was in business rescue, so clearly was financially distressed. We had, however, negotiated better payment terms on the Vanara contract. This coal supply agreement was between Tegeta and between Eskom and not between Optimum and Tegeta. So in terms of a very Optimum Coal Mine point of view, we never supplied the coal to Eskom. We supplied the coal to Tegeta on 30-day payment." So what he describes there is a transaction where, for whatever reason, the business rescue sold the coal to Tegeta. Tegeta turns around and says to Eskom, "We have coal, we can sell you coal." And that is how the prepayment was agreed to. The prepayment or the pre-purchase of the coal was necessary because we were in winter. And operations said, it's actually a very, very long story, sir, if you can allow me. It doesn't start there. It starts in December. Because I heard during the testimony that there was a lot of confusion about why Tegeta was selling Eskom coal to Eskom at 400 rand. There was a mine there at Anot. Anot Power Station has been supplied by Exaro. 40-year contract, sir. 40-year contract that ended in December 2015. The price of the coal on that contract was 1,132 per ton. Compare to the 150 that we were paying at Optimum. In fact, I suspect the reason Optimum wanted an increase was because of this differential. But there was a contract, 40 years, that was coming to an end in December 2015. Exaro wanted to renew the contract at 1,400 per ton. And we said no. We allowed the contract to lapse because it was expensive. And they were not prepared to come down to 400 or 500 rand, which is what I say would have been the market price. Because we were not going to renew at 900, at 700, at 600, no. And they wanted 1,400. So when the contract ended, and that mine is right next to Anot, we went to buy coal from other coal mines in the area, 9 of them, including from Optimum. That coal that they were selling to us at 150 in Henrina, they had an opportunity to sell it to us at 450 rand or 476 rand at Anot. And at Anot, it was a good deal because we had been paying 1,132 per ton at Anot. So in May, this contract came to an end. 6 of the 9 suppliers said they could not continue supplying coal. 3 said they could. Of the 3, Optimum was there. Optimum was in the original nine. The list was sent to me. I can provide it. The list of the nine. Umsimbiti was one of them. I had, I think, Vanara talking about Umsimbiti. So then, Optimum started selling coal at 475. But what was interesting is that they started supplying coal there. By the time we wanted to buy the coal for the winter, the judicial manager says, but we've sold the coal to Tegeta on a 30-day payment terms. And so the prepayment was done with Tegeta. The prepayment was done with Tegeta. The coal, the 576 million, was for coal for May, June, July. By the end of July, in August, all the coal that had been bought in terms of that contract had been delivered. So we bought coal for 576 million and the coal was delivered. There is no question that we lent money and so on. It was a prepayment. Prepayment was very normal in this business. It had been done over and over again. P.S. Marsden also says that. So that is my understanding of what happened. But it is what the understanding that I get from interrogating the officials, the CFO and the head of generation. I believe they will come here and I hope they can explain the matter better, especially because I had not been to the meeting on the 11th.
Let's quickly deal with the guarantee. One or two questions. Why the guarantee?
Which guarantee?
That ABSA gives to Tegeta for
When?
1 point.
In December.
In December of 2015.
Yeah, that's a long story. But let me tell you about the story. On the 1st of December 2015, I had a rotator cuff operation repair, or rotator cuff repair operation, which was to repair the rotator cuff under general anesthetic. During that operation, I had pulmonary edema, which means my lungs were flooded with water, and I did not come back from the operation for about 24 hours, between 24 and 30 hours. And I was on life support. For the rest of December, I was at home recuperating. In fact, I came back in the middle of January. The agreement that you're talking about with ABSA was concluded during December, but I can assure you it was never exercised. Eskom did not lose 1 cent. By March, that guarantee was cancelled without being utilized. So I got briefed about it when I returned, but it was never utilized. I can't say I stopped it. It was never utilized, and in March it lapsed. Mr. Singh, when he comes here, he will explain better. In fact, I think he was the acting GCE at the time.
You're very emphatic in your statement that whoever buys the mine must buy the fine. I think it's clear in the statement. Why does the fine then disappear after Tegeta acquires the mine?
Did it?
Yes. They didn't pay 2.4 billion, did they?
No, they paid 600.
Yeah, but...
Yeah, so it did not disappear. It was 600. But let me tell you how 600 was arrived at. And in fact, this matter also, remember that I took early retirement in end of December. Between January and March, there was an arbitration process. And it is out of that arbitration process that the fine was reduced to 600 million. Mr. Singh and Mr. Koko will tell you exactly about the size of the coal and the issues that led to the arbitration award of 600 million. What I do notice, however, was that Glencore had refused to go on arbitration on the matter. P.S. Marsden refused to go on arbitration on the matter. And he says this in his testimony. He says we used the rules of business rescue to avoid arbitration. I don't understand why they avoided arbitration. When I was there, my position was that the fine of 2.1 billion stands. And I even said to Mr. Glazenbeck, Mr. Glazenbeck, you can't ask us to write off 2.1 billion when we are trying to recover debt from Soweto. How do we go to Soweto and ask people to pay for electricity, and yet we write Glencore's debts off? So I was quite adamant that they should pay the 2.1 billion, but eventually, after I had left, it was reduced through an arbitration process to 600 million.
No further questions, Chair.